initiatives. With me today is Carroll Ogilvie. She's a planning professional consultant who's worked extensively with 155E excavation regulations. And we also have Jennifer Gilbert is a senior planner here at OSI, and she's helping us in the background with our chat functions and question and answer period. So we'll go through the agenda for today. First, we will do an overview of the law, RSI 155E, and the amendments. We'll do a brief review of prohibited excavations, permit exemptions, grandfathered operations, abandoned operations, and then we will go through the role of the regulator, the role of the operator, of other state agencies that are involved in excavation regulations, some relevant court cases to help you out, and the last portion we will do is our resource page before we get into the question and answer period. So for a general introduction to the law, simply put, 155E is the state law that governs the excavation of sand and gravel, specifically the commercial taking of earth. 155E was enacted on August 24th of 1979. A few reasons behind this law to be enacted was to grant municipalities the authority to regulate earth excavation operations within their community. It was also to grant municipalities the authority to enact more stringent regulations than those outlined in 155E. Also to bring lawfully existing operational gravel pits into some kind of compliance with state and local regulations. And the last reason why they enacted the law was intended to help with the location and supply of construction materials in order to assist with the costly and orderly development of the state. At that time, and as development pressures and activities increased, so did the need to identify excavation sites throughout the state. And it's one thing to note with this law, with 155E, the intent of the legislature was the actual emphasis of the law was focusing less on the acquisition of permits than more on the compliance with certain standards for operating, for reclaiming a pit, and for the enforcement of these standards. So that's just something to keep in mind as, you know, we kind of run through the 155E. A few other important points with 155E is that the law invests the authority with the planning board to be named the regulator. Now, unless there is a town meeting vote or a vote of the city council that would authorize the zoning board, the selectmen, or city councilors to serve as the regulator, the planning board would be the ones served by the regulator, serve as the regulator. The law allowed a 2-year window prior to 1979 for pits to come into compliance. So that means they could have been bumped back to 1977 in order for those operators to prove that they were in lawful existence. And the law is pretty clear in that the municipality shall regulate excavation of all earth materials to be used for construction aggregate. So in 1989, there was the first set of substantial improvements that were made to 155E, and they had to deal with the operations and reclamations of gravel pits, as well as enforcement regulations. And in 1991, the 1989 amendments were further clarified to include minimum and express standards. For operations that do require a permit, they are required to comply with the minimum standards. And operations that do not require a permit are required to comply with the express standards. I think the important point to remember with these amendments is that all gravel pit operations are required to comply with some form of reclamation and enforcement standards. The 91 revisions also included some clarification on the reclamation and operational standards to include highway excavations and stationary manufacturing plants, which are both exempt from permits but are not exempt from complying with the express operational and reclamational standards. So, who is exempt from permitting? The laws outlines a little bit more in detail in 155E2 and 2A, but they are basically operation if it was in lawful existence prior to August of 1979. Well, remember, they allowed them to go back even further 2 years. So if they could prove that they were in existence of August of 1977, then they are exempt from permitting. Abandoned excavations, stationary manufacturing plants, and highway excavations are all exempt from permitting. But it's important to remember, while 155E provides exemptions from permitting, it does not mean that those operations are exempt from reclamation and local regulations. There's a few more types of exemptions for permitting. And that's excavation that is incidental to construction or alteration of a building, parking lot, or driveway, harvesting dimension stone, eminent domain regarding stockpiling of earth materials, and there's an exemption for agriculture and silviculture discussed a little bit later. And so who is grandfathered? So when we use the term grandfathered, it's a term that is used when a use is in compliance with zoning regulations at the time when that use began its operation. Grandfathered is not a term that should be used in a way that gives the impression that those operations are exempt from any laws or any local regulations. That simply is not true. There were parameters in the law that described the step that operators had to take in 1979. And again, remember, that law allowed them to go back even 2 years further to prove that they were in lawful operation in 1977 in order to gain their grandfathered status. So if those steps weren't taken, then no grandfathering exists. Now, I understand that documentation back in the 70s may not be the most complete. So I would encourage the planning boards and operators and planning staff to work together to create documentation and start the process of bringing these pits into some type of compliance, some type of grandfathering status as the law allows. And so what is considered an abandoned operation? According to 155E2 Roman numeral 2, abandoned operations, there must be no material that is commercially useful that has been removed from the site for any 2-year period, as well as the owner or the operator may extend the period by submitting to the regulator a reclamation timetable approved by the regulator and posting a bond. So if those things weren't done, then you're dealing with an abandonment. The excavation site is in use and is not a stationary manufacturing plant, but does not meet 155A, the incremental reclamation, or the owner operator has not posted a bond and submitted a reclamation timetable. Either the owner or the operator of the excavation has not secured a permit pursuant to this chapter, nor have they filed a report of existing excavation pursuant within the prescribed period. So if those parameters are not met, then you are dealing with an abandoned operation. So those is the brief description of 155E as far as some of the, the highlights of the law. I will say when you're dealing with excavation operations, remember a few of these practice pointers, something to just kind of keep in mind whenever you're dealing with an operation with 155E. But remember, the law allows local excavation regulations to be more strict and detailed than in the standards of 155E. All gravel pits or gravel operations are required to comply with some form of operational, reclamation, and enforcement standards, either in 155E or in local regulations. The minimum standards of reclamation apply to excavations that require a permit, whereas express standards apply to excavations that do not require a permit. And grandfathered status has to be documented that they were in lawful existence at least in 1977. And that does not mean that operational reclamation and enforcement standards of 155E and local regulations do not apply to them. So in any way, any gravel pit, there is reclamation and enforcement standards that they are subject to. So that ends the abridged history of 155E through the law and its amendments. Carroll will now discuss the excavation regulations from the municipal side with other state agencies involved in the excavation operations.
Thank you, Stephanie. Good afternoon, everyone. I'm going to start with the roles of the regulator, and for simplicity's sake, I will tend to refer to the planning board, even though, as we know, it may not always be the planning board, but in most cases it is. So just to keep things simple, I will use that one term. First of all, I would advise all planning board members to become familiar with 155E. It's not a lengthy piece of legislation, but it is one that can be difficult to interpret and administer. Especially in the early days of the law, it seemed to raise more questions than it answered questions. Some of those things have resolved over time, but nevertheless, it's certainly good to be familiar with it. You also should educate yourself on how to apply and administer this particular law. This is somewhat different from subdivision and site plan. For example, there are different noticing requirements for 155E as well as a different appeals process. So it's important that you are aware of that. If you are unsure in processing an application, especially if it's a big project, you might want to consider engaging a third party to assist you in that process. It certainly, we have seen that lack of understanding and knowledge on the part of the board, not just with this, but with any specialized topic, can lead to regulations that don't really fit the issue. If you don't have a local excavation regulation, you should think about adopting one. That is at the planning board's discretion to do that. It doesn't go to the town meeting. This is like subdivision or site plan. And you want to think of it like that. You shouldn't just rely on 155E to regulate excavations. Think of it like a subdivision. The state law has a process to authorize planning boards to process subdivisions. But if you don't have a regulation in place, you can't really do that. It's the regulation that tells the applicant what they need for a completed application. It tells them what the filing fees are going to be, what the notification periods are, whether or not there are particular performance standards that need to be met. All of those things that define the process that has to be followed in order to get that application through. So it's important to have that. A couple of points about the regulation itself that we see a lot of struggles with over the years, starting with what in fact is an excavation. It's defined by state law as the commercial taking of earth. Well, what is commercial? Typically, we think of that as something that gets sold. But we have certainly seen instances where someone will say, well, but I'm not selling it, you know, I'm giving it away, or I'm bartering it with my brother-in-law, you know, that sort of thing. But the question at some point comes up, you know, when is it beginning to act like commercial activities? Some towns have addressed that by setting a limit on an amount of material that would leave the property, or if it has a productive use at some other location. The same issue comes up with incidental. We know that the state law allows certain projects that are incidental, for example, to agriculture and construction, to be exempt from permit. But at what point do you have so much activity that under normal circumstances, it would trigger planning board review, site plan review perhaps? So again, there are things that some towns have put into a regulation to try to address that. For example, number of cubic yards per year that leave the property, number of truck trips, or a time frame. Let's say the project has to be completed within 90 days, that sort of thing, to help towns get a better handle on what's incidental and what's actually an active operation. One example of this is a project years ago in Plymouth with a large retail site. They were going to move 200,000 yards of material, staying on site, however, as part of their construction, and the zoning board approved that. But an abutter appealed, saying that that amount of material could absolutely not be incidental. This went to court, and the court actually found for the zoning board, saying that it was in fact incidental to the project because it was necessary in order to construct those buildings. It didn't leave the site, and it was not part of any other commercial activity. Another big question that comes up is stockpiling topsoil for reclamation. There was a requirement in the law, or provision in the law, that allowed boards to require the stockpiling of topsoil. That went away in one of the earlier amendments. So now the law says that you can use topsoil or strippings if available, and that's critical term, if available, but in any case, soil that is suitable to sustain vegetation. So it is possible, and the next slide will show a couple of examples. We're having a tiny bit of delay here with our slides, so bear with me, please. There's a publication from the used to be the Soil Conservation Service that has wonderful information in it. There you go, Vegetating New Hampshire Sand and Gravel Pits. So this contains information on various seeding mixtures that can be used to vegetate droughty sites, they're called, that you can do this without any topsoil whatsoever. It takes longer for the vegetation to become established, but it will in fact happen. And the paper to the right is the Soil Conservation Service, an earlier publication that includes some concerns about using topsoil if it has to come from someplace else. If you've got it on site and can stockpile it, that's wonderful. But if you don't have it and it has to come from someplace else, not only is that expensive, but you're disrupting another site that topsoil has to come from. And then you've got trucks traveling over the roads to bring it to this other site. So there are some good reasons to not do that. Now, should you address excavation in your zoning ordinance? It's not a requirement to do that, but this is important to keep in mind that in New Hampshire, as we know, typically, if you don't have something listed in your zoning ordinance as a permitted use, it's considered to not be permitted. 155E is different in that regard. If you don't address it in your zoning ordinance, it shall be considered a use allowed by special exception in any non-residential area of the town, with these findings that you can see on the screen. But that then, of course, leads to the big question, well, what is a non-residential area? Well, we have no clarification from the legislature on that. As far as I know, there has not been a court case that has spoken to this. So that continues to be up to the zoning board to try to determine, if they get an application, whether or not the location that is proposed is appropriate. So your choices are to try to find an appropriate location to zone for excavation, or perhaps if it's not a huge issue in your town, don't do that and let it go to the zoning board if you should get an application, and see how that gets processed. Related to this is whether or not to address excavation in the master plan. Again, this is another provision that was in the law in regarding master plans. For example, it was included in the list of sections to be included in a master plan. That also went away. So it's not a requirement, it's an option, but it's not even in the list anymore. But you still could do that. A good reason to do that is that this particular section, the value of it is that using county soil maps, you could develop a map for your town that would show you probable locations of construction materials, primarily sand and gravel. And with that, you could have some idea of where it might be likely to find these materials, and that could help guide you if you're thinking about trying to identify an area where you could allow excavation to be a permitted use in the district. It's good information to have, and it's a fairly easy map to put together if those people who have access to these soil maps. So that's just something to think about. A couple of things as you're trying to kind of get a handle on the law and how to administer and regulate this, is to have a sense of what's going on in your town. Do you have active pits? Do you have pits that have been abandoned? Those people have maybe just walked away and not done anything with them. So it's always helpful, I think, if you have an inventory of what you've got in town, and call those owners up and ask them if you can do a site visit. Let them give you a tour so that you can actually see what they do and how they do it. I think there is no replacement for being on the ground and actually seeing it firsthand, and not just looking at a paper map. I think it really can help with the understanding, and then helping the board to better process applications. And lastly, on this issue is compliance. Enforcement and compliance, as we know, is always an issue with anything. I would say first and foremost, tread carefully with these. But as Stephanie has mentioned, so many of the issues around whether or not a pit is grandfathered, legal, illegal, all of this come into play if a question comes with compliance. So you really need all of that information in order to whether or not a site is in or out of compliance. So that's just something to be aware of. So now we want to spend just a couple of minutes on the responsibility of the operator. And I would say, first of all, the same thing that I would have to say to the regulators: make sure that you understand the law and whether or not it applies to you. Are you grandfathered? Do you intend to expand? If so, are you going to expand on the same parcel, or are you going to move on to another lot? If you are, was that lot taxed and inventoried for this purposes before you started? So those are things that are important. If you are going to need a permit from the planning board, the board is going to need enough information to be able to make a good decision. Maybe not detailed engineering plans. It depends on the scale of your operation. But if it's a big one, then certainly they will. And also, if you have a permit and your permit has expired, they can be from 1, 5, 10 years. That's up to the regulator to decide the lifespan of that permit. But when it does expire, we commonly talk about renewing that permit. But technically, under the law, there is no process to renew. When that permit expires, you really have to go back and go through the process all over again. That being said, it is possible for the planning board to develop a process within the regulations to streamline that kind of application. If you've been through the process and you have all of this information, the planning board's been out to your site and done site visits, and you have a lot of documentation, they can certainly create a more streamlined process for you. And especially if you also have another permit we're going to talk about in a second, so that can help the planning board and you get through the process perhaps a bit easier than the first time around. So that leads to the next point is, do you need any state permits? There are 2 that typically come into play with excavation. One being through Department of Environmental Services, DES, would be an alteration of terrain permit. If you are disturbing 100,000 square feet or more, or if you are in the protected shoreland, then that triggers at 50,000 square feet. So you would need a permit from DES for that work. For many excavation operations, they hit that 100,000 square feet pretty quickly. So it's not uncommon that an operation needing a permit from the planning board is also going to need an alteration of permit from a terrain permit from DES. And on the screen, you will see the relevant sections that apply to that. The other state agency that comes into play is Department of Revenue Administration. If you're excavating over 1,000 cubic yards, you pay DRA $100 and file this notice of intent at the beginning of each tax year and prior to excavating. This notice is what tells the DRA what you intend to excavate over the coming year. So that's your best guess of what you think you're going to excavate. At the end of the year, you file your report of excavated material. And this is what I tell planning boards. Both of these are very good bits of information to use in their effort to understand what's going on in town. You can look at the intents that are filed at the beginning and look at the report that's filed at the end of the year and see how much activity has been going on the site, and that can tell them perhaps whether or not, some concerns might be raised. Maybe they need to go back and do another site visit. Maybe they've sort of crept beyond the scope of their permit. It's good information to have. And then of course there's the excavation tax that the town gets to collect. So that brings us now to some court cases. This is a list, probably not complete, but these are all of the cases of which I am aware that relate to excavation in New Hampshire. I'm going to talk about the first 2 that are red bolded. Stephanie's going to talk about the other 2. And I would just point out that on the right side, the Bachelor v. Plymouth from 2010. That's the case that dealt with the 200,000 yards of incidental excavation. So these are all available online, of course. So when you can't sleep, you can read all about it. So the first one, Wolfeboro versus Smith, this had to do with whether or not the property owner could expand beyond his existing legal excavation to a new area. And of course, the law says that you can only do that if that land had been previously appropriated, or as 155E says, taxed and inventoried for that purpose prior to the expansion. In this particular case, the defendant did not meet that burden, and therefore was not allowed to expand without going to the planning board for a permit. The next case, Barrington versus Gadd, has to do more specifically with grandfathering. The property owner had an operation that had been ongoing, he claimed, and wanted to claim a grandfathered right to that, to continue it. But upon investigation, the court found that between 1979 and 1990, there had been very little activity. In fact, something amounting to maybe 800 yards of loam. Some of it had been stockpiled, some of it had been bartered and not sold. And the court found that this was a sporadic taking of insignificant quantities, and that just did not meet the test. Just because the defendants wished they had an active operation did not make it so. So Stephanie's now going to cover the next two, and then I believe we're going to have some time for questions and answers.
Okay, great. Thank you, Carol. And I want to thank everyone for bearing with us while we have a little technical difficulties with some of the slides and some other issues going on with that. So thank you for bearing with us as we're all getting used to this webinar training era. So the two cases that I'm going to talk about briefly are going to highlight the preemption issue with local authorities regarding 155E and then local regulations. So the first one is Guildhall v. Goshen in 2007. The commercial excavation business had been in operation since the 1950s. In 2004, an excavation permit was applied for and approved to the applicant and was set to expire in 2007. Now, in the meantime, in 2004, the town had amended their excavation regulations, which was after they had issued the permit. So the plaintiff sued, claiming that the new regulations the town enacted did not apply to them, and therefore it was unenforceable to their facility, and the newly enacted regulations did not apply to them. So the Supreme Court said no to the plaintiff. They said there is no preemption, and the operator of the excavation business must follow either 155E or the local standards, whichever is stricter. And even though stationary manufacturing plants do not require a permit from the planning board, the operator must comply with the express standards in 155E. And however, as to all the other excavations, a local permit is required, and the statute authorizes the local regulators, which would be the planning board, to create their own regulations, provided they are at least as stringent as the minimum standards contained in the statute. The Supreme Court stated, "We conclude that RSA Chapter 155E authorizes municipalities, in the context of excavations that require a permit, to impose regulations more stringent than those contained in the statute. The town's ordinance does just that and is therefore not preempted." Practice point being, the state law does not preempt local regulations of excavations that require a municipal permit under 155E. And so the next case is Carroll v. Rines. Again, this is another municipality preemption case. It was issued in 2012, and the Supreme Court kind of tweaked their decision in 2013. That's why there's 2 years with that. But it touched upon the applicability of uses in the zoning ordinance, as well as relating to the local authority's ability to enact excavation regulations, which are more stringent than 155E. So the plaintiff operated 4 different excavation sites over several years with 2 different purposes. One for constructing a highway and the other as excavation incidental to constructing a building. Now, the 2 sites are exempt under 155E2 and 155E2A, so the plaintiff was not required to obtain a permit for those excavations, but the town claimed they still needed a ZBA variance because excavation was not permitted in that zone. Plaintiff argued they do not need a variance because the zoning ordinance does not say it was required. So the court quickly dispatched the plaintiff's first claim that the zoning is stating that the zoning ordinance is permissive and is intended to prohibit all uses except those expressly permitted or incidental to uses permitted. So in other words, unless the ordinance says a use is allowed in a certain zone, it isn't. And while excavation incidental to construction of a building was permitted, excavation related to a highway was not permitted and required a variance. Then the court looked at the preemption issue and again ruled in favor of the municipality. They ruled a zoning ordinance may prohibit excavation in certain zones, and a variance may be required for that excavation even if a permit under 155E is not. So meaning that while municipalities cannot alter the statute as it applies, they can't change 155E to the operational and reclamation standards for those exempt type of applications. Local regulations applicable to highway excavation is not preempted unless they gain an exemption locally from the zoning board or from the planning board. So it just reminds us that the towns and cities may impose regulations that don't interfere with the state's purpose, and that those regulations may be more strict. So this concludes our presentation of digging into 155E. So we will be turning into the question and answer period. If we have any of those, let's see, we're having a little difficulty here. So we'll go through our resources available on our website. There's a link to the law itself, 155E. And there's other resources there are Southwest Regional Planning Commission's handbook for excavation regulations and some materials that Carroll spoke about in her presentation. We go to the question and answer period, so you can use your chat function or raise your hand, and you can click to unmute yourself, and we will take your questions and answer your questions as best we can. If we're running over, if anyone still has questions and we're still in the question and answer period, Carol and I will be available after 1 o'clock as well.
Stephanie, we have 3 chats questions.
Okay.
Yeah, I can write it into a chat.
Let's see, we'll go with Susan Slack. The AOT permit seems very important. Should a planning board reviewing a site plan application for an excavation or a permit under its own 155E regs wait until the AOT is approved to be knowledgeable about what DES is requiring? Is this the best way to protect groundwater or determine depth of excavation? You know what, Susan, I am a little bit old school.
Want me to take that, Stephanie?
I'm sorry? I would say yes. I think I would, you know, at least make sure that the DES versus through the AOT permit, vice versa, back and forth, that you know what you're getting into. And even though the law says that, you know, the permit local planning board can't hold up an application, pending state permits, I do think it is important that the planning board know what the state approved. So, and I do think that that is one of the better ways to determine the depth of excavation and the aquifer thing, where the AOT permit has a little bit more knowledge and a little bit more background for those types of issues. So if those permits are already obtained, or already in the process of being obtained, and the planning board is aware of that, I think it makes their job a little bit easier.
I agree.
Question for Carol from Tara Bamford. Do you have some examples of local excavation regs that you feel are good and user friendly, Carol?
I do, Tara, and I'll send you a few.
Very good. Let's see, from Kyle Pimentel. Can an applicant make the case for an incidental exemption for a future use? For example, an applicant wants to remove roughly 20,000 cubic yards of materials from a site strictly to level a property to make it commercially viable. No depression, no pit. Any surplus would be used on site for grading activities. Could a planning board grant the exemption based on the interpretation that the excavation is incidental to the planned future commercial use of the property?
Shall I answer that?
Yeah, go ahead, Carol.
Okay, well, the simple answer is that in order to be technically incidental to construction, those building permits have to be in hand. So I don't see how a planning board could grant that preemptively. They need to apply for the building permit and then make their argument that what they're doing is incidental to that construction, and that would never get to the planning board unless, of course, someone made an issue out of it.
Right, yeah, I would agree. Okay, the next question is from Mark Sunin. If AOT permits are typically good for 5 years before renewal, how long is a good practice for a municipality to authorize permitting?
Well, I have, sorry.
Go ahead, Carol.
Oh, thank you. Well, there's one town I work with that has in fact worked very hard to get their process in line with AOT so that the operators don't have to go through this twice. So we've set it up so that well, initially we set it up so that their local permit would come due when their AOT permit comes due. But in fact, we just made another amendment to extend it out to 10 years. And with the possibility for annual reviews through the intents and the report, so that if something significant happens within the 10 years or through their AOT permit, that they may need to come back to the planning board. So that's one way of doing it.
Okay, very good.
Stephanie, we have 2 hands raised. Delisa, do you want to go?
Yes, please. Yep. Can you hear us?
Is this Lisa?
We can.
Yes.
Yeah? Okay.
Remy doesn't like the snow.
Hold on. Say that again. You might have to get closer to the microphone over here. Hold on 1 second.
Hello, can you hear me? Hello?
We can hear you now.
Okay. Yeah, this is Brian Brock, Candia, New Hampshire Selectman and Planning Board member. We've got a unique case where we've got an illegal excavation site that's 30 plus years old. The owners have changed. They have finally come in after the Board of Selectmen required them to bring in reclamation plan before they proceed with any future development there. So they have done that, and it required the ZBA to approve it because it's in a residential area, which is not approved for excavation. So this is an old case. They did bring it to the ZBA. The ZBA granted them. So we'll be coming back to the planning board. And like I say, they do have a reclamation plan. We haven't gone through the whole thing as a planning board yet because they just got approved from the ZBA. Is there anything that we should be really looking at closely? Because they are requiring to excavate about 400,000 cubic yards of material to reclaim this site. So is there anything that really, any flags that we should be looking at or something?
I'll let Carroll take most of this question, but I will jump in to say that I think it's imperative to make sure that you get some kind of reclamation bond from the applicant, some type of site security, a reclamation bond.
Okay.
Okay. And as far as other permitting things, like, Carroll can jump in as well.
Yeah, because they're also asking that this project is going to take like 2 years to complete. So there's quite a bit of time involved.
Right. And,
Yeah, actually, this.
Go ahead,
No,
Carol.
go ahead, Carol. I was just going to say, it sounds as if, I think maybe we could have an offline conversation about this, because I would have a few questions that I would need answered before I would feel comfortable with providing any general guidance. So, but my email contact is on this page. So perhaps if you could shoot me an email and then we can communicate afterward, and I think I could probably do a better job of helping you.
Okay, that sounds good.
Great, thank you.
Great, thank you.
Thank you.
I'm going to go to a few more raised hands.
Yeah, we have James Burden next.
Hi, James.
Hi all, thanks for doing this. And Stephanie, I think you and I have already talked a little bit about the case that I am working with, but I just wanted to ask a few general questions about things that we've come up with.
Sure.
First, we have an excavation permit application that the town that I'm working with doesn't have their own regs, so we're acting specifically under 155E. And we ran into the fact that, because they're disturbing enough area that triggers site plan review under the site plan regulations, we have to have the two applications going at the same time. And our site plan reg application fee is based on square feet of disturbance. So we ran into the issue of having a massive site plan application fee. And that held up the project probably for a good 6 months at the beginning, just on its own, in terms of figuring out, the applicant was asking to waive the fee or waive it in part and pay it in installments. And, that led to a whole discussion about, whether or not the planning board could waive it. They decided no, they couldn't, because the fee schedule was done by the Board of Selectmen. So, they just sort of went around in circles. So I was wondering if other places had thought about how their fee schedules interact and had, for example, done something like set a maximum site plan fee, but then would set a larger excavation permit fee to sort of pick up where that left off, or how those things interacted. And then the other question that I had is something that's come up over the course of discussion, and I believe the plan standards that are required by 155E for what information you need to show require that you show the depth of the water table. And in this case, The applicant hasn't done that and has made the case that because of the location of where the bedrock is going and how deep they're proposing to excavate, one, that water table is going to be in different places because the groundwater is going to pool on top of the bedrock. But two, that they're going to be excavating down below what any sort of test pit would show as the water table. And it didn't really seem like something that got my board's attention, but it was something that I was wondering if you had any thoughts about.
The first thing, James, the fee stuff is always kind of difficult because if you're looking at the fee schedule, as the intent is that there's square foot, there's square footage impacts for the area. It's almost one of those things that it's kind of hard to determine. Excavation operations have, a lot of impacts to the community, to the land. So, I can understand how these fees can get to be very large and hold up a project. Maybe they can work something out where they could put it into the reclamation, bond, kind of roll it into just a different point of, different, pool of money. But, it does bring up, kind of that catch-22 is that they are large, impactful operations, and the site plan fees are intended to help with that on the administrative end, that it's going to take a lot of work for the planning board and for staff to go through that. So I guess I don't really have a good answer for you for that, except maybe staggering, maybe spreading it out. Maybe your idea of, kind of changing the permit fees instead of into the site plan fees. But those are kind of, my thoughts on that. So Carroll, do you have any thoughts on what to do with some of these larger fees that the operators could come into?
Yeah, that's kind of a messy one. I mean, first of all, the law says that the excavation permit itself can't be more than $50. Now, a site plan fee, that obviously is a completely different situation. It's not uncommon that we see site plan fees kind of distinguish between ground disturbance and building construction. I mean, we understand that the purpose of the fees is to offset what it costs the town to process and administer the application. But I can certainly see where a site plan fee in this case could be monumental. So potentially, obviously, the selectmen would have to agree to it until the planning board could at some point maybe, put that in their own bailiwick with the site plan fee that they could then themselves waive. But if you could take that money and either, as Stephanie said, apply it toward reclamation or put it into an escrow and use it to offset costs of application processing, review, having an inspector out there to do some of that work that the planning board, some of that specialized work that the planning board couldn't do. Perhaps that might be one way of getting at it.
Yeah, I would agree with that. And if I guess I would institute some kind of help with the AOT permit for the second half of your question there, the AOT permit process, James, for the second half of the question there. Okay, we can take another, let's do a chat question now. We have a question from D. Daly. Some long-standing gravel pit permits we are inspecting do not have specific reclamation plans or plans for working areas. Is there guidance if we can ask for info to supplement the permit during the intent to excavate process?
Well, if that means when they're submitting their intent to excavate form, I don't see how that could happen. But at some point, these permits, I would imagine that they have an expiration date. And I would think that that would be the best opportunity to get these other plans in place that are apparently not there now.
Yeah, I would agree. There definitely should be, I mean, there should be some tightening up of getting some kind of reclamation plan in there. You know,
Mhm.
that's kind of important. They're not exempt from reclamation, from having reclamation plans. So
Exactly.
I would also work on that.
Yeah. And you can't, at any rate, until they get before the planning board in some fashion, there's, you know, you don't have the authority. I mean, the intent to excavate is not a planning board document. So I don't think that gives the planning board any authority. You've got to get them back before the board, either
Right.
through a permit renewal or that they're not in compliance, and you bring them into compliance.
Right. Yep, I would agree with that. Yep. Okay, I think we still have a few more hands raised for anybody else who has a couple of those to go through.
We also have some callers online or
Okay.
calling in. If anybody a caller has a question, please just unmute yourself and go ahead.
Anyone else having any questions? If you are on the phone, just make sure you're unmuted. Just click your microphone.
Hello, can you hear me?
Oh, we can hear you a little bit. Yeah, hello.
Okay. My name is Lisa, and I have a couple of questions. One is how the abutters, between approving and disapproving abutters, are determined. Is it the property owner that would be the abutter's responsibility to know that they should declare what type of abutter they are, or is it the operator's responsibility?
What do you mean, Lisa, when you say what type of a butter they are?
Because an approving abutter versus a disapproving abutter makes a difference of 40 feet in how close the operation can go to the boundary line.
I think I understand what, hi Lisa, I think I understand what she's asking. And it's something I hadn't actually given a lot of thought to before, but it raises a really good point. If you're in a butter, you're not going to know whether you approve or disapprove until there's an application that's being processed and you get your notice. And as far as I can see, that's really your best and maybe even only opportunity to weigh in as being a disapproving abutter. If you've got an objection with the distance from your property line, unless of course the operation starts and it's not in compliance and they get closer to you, and then that's an enforcement issue. Then you've got to complain to whoever's in charge of enforcing and try to resolve it in that regard. But ideally, it would get settled at the planning board when the permit is being processed.
Well, and what about like grandfathered pits that have been there a long time?
Well, I mean, they still have to comply, even if they're grandfathered, and if they're getting closer to the property line and you've read and the abutter has registered an issue with that being too close, then again, the enforcement entity should be addressing that. I mean, that's still a right to not have that encroachment, whether that's a new application or not.
what we have is we have the operator saying that it's the abutter's responsibility to disapprove, and a property owner saying, I've expressed that I'm not happy about the noise and the pit being next door, and that still, because somehow there wasn't paperwork filled out, that didn't qualify as being disapproving. Like the property owner doesn't even know what the process is to be a disapproving abutter, and so it brought up the whole question of how do they even declare that? Like, it doesn't seem like there's a form, or it's just I mean, how many residential people are going to be approving abutters was kind of, we were just surprised.
Right. Yeah. Well, I think that highlights, one of the points I made earlier, that this is a law that certainly often leaves more questions. I mean, there isn't a process that I'm aware of other than you get your opportunity at a public hearing. And if there isn't a public hearing, then it becomes an enforcement issue or battle, unfortunately, in too many cases. And if whoever is responsible for enforcing that, I mean, I don't.
And then my other question is in regards to municipal sand and gravel operations, and kind of the complications that can happen because there isn't a permit per se, and an oversight of the planning board involved through that lack of permit. The challenge that then happens by not having a reclamation plan if it doesn't fall into the AOT, and not having a sunset date. So especially in regards to the sunset date, which normally would be able to be established by a permit expiration date. If there's any ideas, if a town was interested in that, what avenues would there even be?
Well, even though we know towns are allowed to be exempt from their own regulations, my opinion has always been that towns should set the example and follow their own regulations. If they expect other people to do it, I think they should do it as well. But obviously, that's my opinion. And, if a town refuses to do that, then, the alternatives are probably somewhat limited. Stephanie, I don't know if you have anything you want to add to that.
I agree wholeheartedly with you that yes, municipalities are exempt from regulations, but I think that they need to set the standard. And, I think, not having a reclamation plan, I think is kind of an issue, at any point, because whether you're a municipality or whether you claim that you're a grandfathered pit, remember, there's certain parameters, not just because you've been doing something for a long time doesn't mean that you're grandfathered. So just kind of remember that even if they're claiming that they're grandfathered, and I understand that, documentation, over the years kind of is hard to come by, but that doesn't give them carte blanche to do what they want, when they want, whenever they want. They're still held to reclamation standards. They're still held to 155E. So I would, in essence, kind of try to use the same type of advice as far as the municipalities. I think it's really important that they set the standard, set the example, and follow their own regulations and their own state regulation, the state regulations for that.
Okay, so are you aware of a way though that would kind of set a time frame or a process the town could do that? Like the town isn't really aware of how they would do that since they aren't permitted.
I mean, I guess I would try and push the envelope and have them come in and talk about it with the planning board. I mean, you know,
Right.
I think now is the time to try to start to get something on paper. You know, they're probably not going to be excavating forever. Do they have a 5-year plan? So, as an example. So maybe the planning board at that time can, again, work with the applicant, work with the municipality to say, okay, show us a plan of what you're up to, how much you think you're going to be taking from the site. You know, the other intricacies, what are your hours of operation? Because there are abutters that need to be taken into consideration.
Yes.
So those kinds of things, I mean, I think it would behoove the town to be a little bit proactive and to say that this is what we're kind of looking for. And a reclamation plan can be done in stages. You know, if it's a huge site, are they going to, you know, they can reclaim it within, you know, 5 years. They can do certain sections of it. You may want to make sure that they aren't excavating in an area before they have reclaimed an area. So that may be something else that the board would want to look into. Are they just going to keep on excavating this site and have a huge site that's not been reclaimed and have slopes open and they're still, you know, still taking from the site? So there's a few things that I think that they should kind of iron out and not be afraid to ask. I think it's the fair and equitable thing to do is to come in compliance and have the conversations about it. And documentation of things is really important.
Okay. Okay, thank you.
Yeah, you're welcome.
We have a chat that came in that's related to that answer too.
Okay. From James, the municipality could just present to the planning board as a governmental use of land and give the board the option of asking for a hearing. That would make the planning board entitled to non-binding comments at least. That's another really good avenue, James, to think of. Absolutely.
Yes. Yeah.
To get them in and, you know, when you have those governmental uses of land, you know, you could still ask that applicant, even though they don't have to, but you could still ask the applicant to come in, notify the abutters, let everybody know, be aware of what's going on. Just give people an understanding and being, you know, transparent as to what they're doing will carry a long way instead of the town going in there and doing what they want when they want. It doesn't really send a
Exactly.
message.
Showing good faith.
Yeah. And, you know, on the flip side of that, you know, showing good faith by working with the operators, you know, I mean, you know, I've had, you know, experiences where operators have just, they've been doing it forever. Pits are long operation, you know, they're not over with in a few years. Some of the bigger ones can go on and on. They can sit dormant for a while. They can come back up, change owners, whatever the situation is. They've always seemed to just kind of be the biggest project around. And it takes a lot of effort and a lot of cooperation on both sides. The operators can't think that they're untouchable, and you know they need to work with the towns. And the planning boards have every right to ask for third-party review, ask for reclamation bonds, and those types of things. Okay, we have another question in the chat here. Is there a specific checklist for how to conduct an on-site inspection?
Well, there is certainly can be a checklist in the regulation that would include all of the items that would need to be submitted for a completed application. And it would also include the things that you would want to be looking for. So things that you want to see on the plan are also, to a large extent, the things that you would want to see when you're on site. And there are certainly plenty of examples around of excavation regulations that are you know, more detailed for larger projects that would, even though I haven't seen one that specifically says how to conduct an inspection, but the checklist with information that the board would be looking for, I think gets you pretty much to the same place.
Yeah, I would agree with that. And I would also kind of throw in that if there's an opportunity for the community, for the planning board to hire a third-party engineer, I would strongly recommend that. They're authorized through the statutes to do that. For an engineer or another professional that would work on behalf of the town, that would work on behalf of the planning board to be, you know, right there on the on-site inspection. They'll be earning their money, paid for by the applicant, but they're there to protect the town. And so they would be the experts to go in and know exactly what kind of slopes would be the best to have. They would know, look at the plan, and they could be able to go out on site and, you know, really point out topics, situations, reclamation, standards, reseeding, whatever the case is. I think part of that checklist or part of that process should include a professional. And that is, again, something that they are allowed to do, that can be paid for by the applicant throughout the process to make sure that those standards are their reclamation is being held.
Right.
Sure, you're welcome. Is there any other questions on the phone? Anybody waiting on the phone? Okay, I think that we could maybe kind of wrap this up. We ran a little bit over. If anybody has anything, you know, quickly they want to add, people need to jump off. We understand that. Thank you very much for joining us. The recorded webinar will be available on OSI's YouTube page tomorrow. And again, we have any further information that you're looking for, you can reach out to Carroll or myself. And please visit our website, which is located on the contact page. And we'll be glad to help you out with anything else that we can. Last call for anybody else with any questions. Hands raised. And thank you for bearing with us with some of the few technical difficulties that we were overcoming, and we appreciate your time. And thank you very much. Have a good day.